our topic today, the latest on DACA advanced parole and marriage-based options. Thank you all for joining us. Today we do have some time reserved at the end for question and answer. So if you do have any questions that you would like answered, please add them in the question and answer portion of the screen. We will not necessarily be monitoring the chat area. So if you have any questions, please don't put it in chat, put it in the question and answer portion. The Alcorn Story. So thank you for joining us today. Anita, partner at Alcorn Immigration Law, together with my associate Cori. We are attorneys at Alcorn Immigration Law, and what we do is we overcome borders, expand opportunity, and connect the world by practicing compassionate, cutting-edge, and rigorous immigration law in the service and betterment of humanity. So what we do, we focus on helping everybody worldwide, nationwide, that we can help, and we very much pride ourselves on maintaining a high success rate. Again, here I am, Anita Koumriqian. I'm a partner here at Alcorn Immigration. I specialize, and I have it holds a special part in my heart, family-based immigration. It's what I love doing the most. I am the partner at our firm that focuses and handles on all of case production. So I kind of have my hands in a lot of different pots at our firm, but family immigration law is near and dear to my heart. I have experience practicing family law as well, so it helps in my family-based immigration practice, specifically with my marriage-based cases. Immigration is very close to me. I was born outside of the United States. I was born in Iraq, moved to the US when I was 5 years old. I'm a proud American now. And I've been raised, ethnically, I'm 100% Armenian, and I'm so proud of that. So immigration is very much a part of who I am. To prove to you that I was an immigrant myself, here's a copy of mine and my sister's, our green cards that are not green. They are pink. That's me down there. Back when we were known as resident aliens, not necessarily green card holders, permanent residents, but we were aliens. So 2 cute little aliens. This is my incredible associate Cori. Why don't you introduce yourself, please?
Yeah, so like Anita said, my name is Cori. I am the Family Immigration Associate Attorney at Alcorn. I am an alumni from UC Santa Cruz and also alumni from Santa Clara Law, just like Anita. Before working at Alcorn, I was working with survivors of trauma in their immigration matters at a nonprofit. It was a very challenging but rewarding job. And I am a proud child of immigrants. I do come from a very diverse family, so immigration always felt like a natural fit for me, and I've really enjoyed my time working in immigration.
Awesome, thanks, Cori. So this is our incredible team. These are all of the kind, smiley, compassionate people that help us serve all of our clients. All of the people that you see here, they're either immigrants themselves, the children of immigrants, maybe they're married to an immigrant, whatever it may be. That's who we are. Obviously, we're not hiring based off of that, but it's just a part of who we are at Alcorn. And it really helps us, in our opinion, to kind of be able to put our shoes in our clients' our feet in our clients' shoes, kind of understand them in a significantly more compassionate way. So super grateful to work with all of these brilliant, kind, and truly brilliant people. So that is our team. We are very proud to have all of these individuals and just these power partners that we have as a part of our network. So super grateful for all of them. So this is what you're here for, right? What do you need to know about immigration? Everything. We all need to know everything about immigration, but immigration is such a huge and vast area of law that there's so much to know. There's a lot of different components of immigration. There's employment-based immigration, family-based immigration, humanitarian-based immigration, as well as removal defense. A lot of attorneys will focus on one aspect or one area of immigration. We focus on a couple, which is really cool, and we have various leads in our departments. But as this next slide says, immigration law is so incredibly complex. If you don't know it, if you're not a professional in it, raise your hand, ask for help. Seek the assistance and guidance of an immigration attorney, counsel that you know, that you like, that you trust, that you can help have them hold your hand throughout the process. A lot of people will ask me, Anita, Cori, can I do this on my own? And I tell them, I mean, you can Google it, you can try your best to kind of navigate the avenues of immigration law on your own, but it's hard. It's sometimes we've been doing this for years. I don't even know how long I've been practicing now, but we've been doing it for so long, and there's truly something new that we learn every day, especially because immigration law changes so often. So raise your hand, ask for help. There's two typical pathways for immigration. Cori, can you walk us through this, please?
Yeah, so two typical pathways, as you can see here on the slide, for citizenship. One is you enter the US on a visa, you adjust your status to a green card holder, and then eventually apply for citizenship. Second pathway is you apply for a green card abroad and you enter the US as a green card holder and then ultimately apply for citizenship. So those are the two typical pathways there.
Awesome. And then a common misconception is somebody who wants to enter the United States or is in the United States and doesn't have valid status, and they'll reach out to us and say, I want to apply for citizenship. And we'll ask them, cool, when did you get your green card? And they're like, no, that's what I want. So there is kind of pointing out the difference of a green card, your permanent residence. Once you've been a green card for either 3 years or 5 years, depending on some more of your life and case details, then you're eligible to become a citizen of the United States. As a green card holder, you do not get an American passport. You're still a citizen of your home country, either whether it's the country you were born in or a country that you thereafter became a citizen of. But it's not until you become a US citizen where you say the oath of allegiance to the United States, that's when you get your US passport. Immigration during COVID, I have to take a fat deep breath before that one. It has been a difficult, almost full year now, being an immigration attorney during COVID. Of course, yes, it was a difficult 4 years before that with just an administration that was anti-immigrant, but specifically these past 10, 11 months now, have been especially difficult. So Cori, why don't you walk us through our trials and tribulations of being an immigration attorney through COVID and just being an immigrant through COVID?
Yes, definitely. So there's been a lot of changes with how cases are being processed in general because of COVID. Just to give you some highlights here. So there have been significant delays in biometrics and interviews at our local field offices here. USCIS did close completely for all in-person services from March to June of 2020. They have been reopening slowly and rescheduling appointments and scheduling new appointments since June, but it is a very, very slow process. So it's very normal if it's taking months and months for fingerprints or biometric appointments to be scheduled, interviews to be rescheduled or scheduled again. In addition to that, USCIS is now encouraging and offering telephonic appearances for attorneys. So they are encouraging attorneys to appear telephonically at their local offices. Anita and I have both attended interviews telephonically, and I think it's safe to say that it increases safety for both client and attorney, but also the client is still getting that same experience with having an attorney present there. In addition to those things going on at the local offices, there is still a presidential proclamation in place that is preventing green cards from being issued at consulates abroad. All the consulates are reopening also at their own pace, ensuring safety of everyone in their office and for people attending their interviews. So that is also creating a backlog, but they are also working at reopening and rescheduling those appointments as well. Both the embassies and consulates abroad and the local offices are also offering expedited appointments, but it is very challenging to get these expedited appointments during COVID. But it is still something that's worth trying if it's something that you qualify for.
Right. So if you feel that any of these could possibly apply to you, reach out to us. Let us see whether or not this is an option for you to determine what your options are moving forward. So DACA, let's talk DACA. I think one of the best pieces of news that we've received in 2020 thus far was the fact that DACA has been revived. I remember when that news first came in, and it is truly one of the greatest accomplishments in recent immigration history, in my opinion. So what does that mean, DACA being revived? USCIS is now finally accepting new and initial DACA applications. DACA being deferred action of childhood arrivals. This is what kind of just some of the guidance in regards to DACA, the great news that we have been able to share, where they're not only are they accepting new DACA applications, they're being accepted for the full 2-year the 2-year capacity. There was a point in time where they were only valid for the DACA grants were valid in 1-year increments, and now they're valid for the full 2-year increments, and they can be renewed. Same with the employment authorization, but they're also, which we'll talk about in a second, advanced parole is now back as an option, which we'll talk about in a second. So let's walk through, Cori, the DACA requirements, and I mean, they're listed on here, but let's walk through the requirements, Cori, and talk about the challenges that people will face with these initial DACA applications.
Yeah, so I'll go ahead and run through these requirements. But basically, to qualify for DACA, you do need to be under the age of 31 on June 15th, 2012, came to the US before you turned 16, lived in the US since June 15, 2007, and then have been present in the US on June 15, 2012, and at the time that you do file your DACA application, as well as had no lawful status on June 15th, 12, and you have to have either been in school or graduated from school or served in the U.S. Armed Forces and have did no crimes.
And then, so what's going to be difficult for these new initial applicants?
I would say the thing that's going to be most difficult for initial applicants today is going to be providing sufficient documents to prove their physical presence. So you do have to show that you've been present in the United States since 2007. So that is quite a good amount of years. So people may have difficulty coming up with those documents to cover that entire time.
And what are some of the documents, Cori, that individuals can start to see? Can I have them?
Documents, like examples of documents that could be used could be immunization records, any other medical related records, school records, employment records, even residential leases could be used. So anything that is going to have your name on it and show that you were in the US.
So hypothetically speaking, let's say I want to apply for DACA now, and I'm not on any leases. It's all under my parents' names. Is that an option for me?
Yes. Yes, that is an option. You can use documents that maybe you're not the primary person on that document, such as leases or maybe even taxes. For example, I've had people come to me with their parents' taxes and they're listed as a dependent, but leases definitely as well if you're listed as someone who was in that house at the time. So those are definitely documents that could potentially be used to prove your presence.
Okay. And then crimes. I mean, as an immigrant, I mean, just as human beings, we should all strive to not commit crimes, right?
Correct.
Our crimes are a little bit different for DACA. Tell us a little bit about that.
I would say in general, crimes are very significant for DACA. If anyone is considering in renewing their DACA or applying for DACA for the first time and they do have any kind of charge, whether they're convicted, the charges are dismissed, it's expunged, I would always recommend talking to a profession, talking to a attorney that you trust, who can guide you through the process, because it takes a complete analysis to determine if your crime, whether, like I said, even if it's just a charge, how and whether it's going to impact your DACA application.
Right. And crimes specifically related to substance abuse are really bad on DACA applications. So,
Hmm.
of course, nobody wants a DUI on their record, just in general. But those who are dreamers or hopeful dreamers, be super careful about this. It is not worth risking it. So, um,
And then an interesting thing just to add there is, alcohol related offenses while you are driving, are technically under the vehicle code, but they are still part of the criminal record when it comes to immigration. So something to be aware of.
yes, absolutely. Cool. So moving on. So I mentioned very briefly advanced parole and how that is back as an option as well. So advanced parole. What is advanced parole?
So advanced parole gives you what advanced parole can do for a person who has DACA status is it can give them permission to leave the United States and return to the United States. So without advanced parole, if someone who has DACA status leaves the United States, they automatically terminate their DACA status. You cannot leave the U.S. without this advanced parole document. So this advanced parole would allow you to travel abroad and then return to the US. So in order to apply for advanced parole, you'd have to have a sufficient reason for requesting it. So some of the reasons that we have here are humanitarian purposes, educational purposes, or employment purposes. So humanitarian could be attending a funeral service, assisting a sick relative. Educational could be semester abroad programs. Employment purposes could be overseas interviews, assignments, conferences, things like that. And then USCIS would have to determine that that is a sufficient purpose to grant you that advanced parole travel document.
Yeah, thanks, Cori. So just kind of adding on to that, USCIS has to approve of this before you leave the United States, obviously. But specifically, if they're going to deny your advanced parole request, then it's back to the drawing boards. You can't leave the United States. A lot of individuals who apply for adjustment of status as well, which we'll talk about in a second, they apply for advanced parole, or that's just a part of the application process that we support with as well. The advanced parole that we're filing for in connection with a green card application is completely different than advanced parole that is being filed through DACA. Yeah, sure, the form is the same, but on the advanced parole applications connected to an adjustment of status green card application, those we file bare bones saying the date of travel is to be determined. The applicant may or may not need to travel for personal or business reasons, and USCIS is totally fine with that. If somebody in DACA status or a dreamer were to file saying to be determined, maybe I'll have to travel, USCIS will promptly deny your application. So with that, you need a very convincing and compelling reason that you have to leave the United States. Humanitarian purposes pop up a lot as exceptions with USCIS, and they truly mean it. Somebody, and knock on wood, this is not the case for anybody, but somebody has to be dead or dying for USCIS to be like, okay, fine, we'll approve this. That's okay. And for the most part, those are the advanced parole applications that I've that Cori and I have both drafted in relation to DACA applications and for our dreamers. With that, we're showing the United States, you know what? John has an aunt that he hasn't seen for 20 years in Mexico, and aunt is not doing very well. Here's proof of her health issues, and please let him go. It's his aunt's one final wish to see her nephew before then. And I mean, years ago, back when advanced parole was an option, it was for the most part successful. Of course, you can never guarantee anything with USCIS, but that's kind of the things that they're looking for. And then marriage-based immigration options. What I was talking to about a little bit earlier, just adjustment of status. Adjustment of status is when somebody is in the United States already with valid status of their own. So maybe they've entered the United States and they have, like, for example, an H-1B visa, or they're in the United States as a student. And they're in the U.S. They had a legal entry into the United States, and then thereafter, maybe they got married to a United States citizen. Maybe they have a child who is a United States citizen that is now 21 years old, and that can petition for them. So somebody who can file an I-130 underlying foundational petition for them can then maybe simultaneously file an adjustment of status application. But that's when you begin your journey towards getting your green card. You file the I-485 adjustment of status application, and then you're waiting, of course, for a handful of things. On the screen right here, you see a pathway to green card. These are pre-COVID timelines. I know we will be sending this this timeline out to all of you who have joined us today, just so that you guys can see it and have a copy of it for your records and just for you to take a look at. But that's what adjustment of status is. You're adjusting your status from whatever your status is to permanent resident. Cori, do you always have to be in valid status to apply for adjustment of status?
Not necessarily. You don't necessarily have to be in current valid status at the time of filing an adjustment of status application.
So yeah, so with that, it depends. It depends a little bit. If you again feel like you're in that position, reach out to us and we can see what your options are. How to get a green card through adjustment of status. Like I said, you need somebody who would be filing an underlying I-130 petition for you. An I-130 petition is a petition for alien relative, your spouse, your child, your parent, anything of that nature. And then what comes after that is you file that application. About 6 to 7 months, again, pre-COVID times, you get employment authorization and perhaps advanced parole international travel authorization. And then thereafter, you're waiting for your case to be scheduled for interview at the local office, depending on where you're living. Once your case is scheduled for interview, assuming everything at that interview goes well, then you can expect to receive your green card in the mail within a couple of weeks after that. At the interview, what they're asking you is questions about your relationship. When did you meet? How did you meet? Again, if it's marriage based, we're talking about when did you meet? How did you meet? Who was at your wedding? What joint documents do you have together? Joint bank account, lease agreement, things of those nature. And then at the same time, in addition to asking you questions about your relationship, they're also going to be asking questions to the applicant's spouse, the one who's getting their green card, just to make sure that they're actually eligible to get their green card. How did you enter the United States? Do you have any immigration complexities? Have you committed any crimes? Are you coming into the United States to commit money laundering or things of those criminal nature? So those are what are at question during these interviews. If sometimes people don't qualify for adjustment of status, maybe they're the individual spouse, or oftentimes maybe their parents, they're not in the United States, and they want to bring them to the United States from their home country. So this is that second pathway Cori mentioned earlier on, several slides ago, where somebody is entering the United States immediately as a green card holder with the permission to work in the United States right away with their green card, permission to travel right away as a green card holder, everything of that nature. So who can apply through consular processing? Again, it's as long as you have a family member or employer or anybody who qualifies to petition for you, then you could potentially benefit from a green card, maybe a United States citizen spouse, green card holder spouse, a parent, a child, a sibling even, relationships of that sort. How do you get through your green card through consular processing? It's a 3-step process. It's a bit of a lengthy one, especially depending on the consulate that you're working with. But the first step is, again, filing that I-130 petition, that foundational petition with USCIS. Once that's approved, then your case gets forwarded to an entity called the National Visa Center, where you have to provide additional information documents to the Department of State at that point in time. And then once they have everything that they need from you, the National Visa Center will work with the consulate of the home country of where the beneficiary spouse is living to schedule an interview at that consulate. Once that consulate interview is scheduled, you attend that interview, and it's only the beneficiary spouse that has to go. So not the US citizen spouse, the foreign national spouse has to be at that interview. Oftentimes people ask me that, do I have to go to our home country so that I go to their interview? Nope, it's not a requirement, you don't have to. So again, applicant, beneficiary spouse goes to that interview, assuming everything goes well. They'll take the passport from you, which some people are like, what? I have to give them my passport? Yes, that's good news. That means that they're ready to take your passport to stamp in or place in the immigrant visa stamp in your passport. And that's the visa foil that says this person is a green card holder. Once you have that, within 6 months, you use that to enter the United States from there. You enter the United States again as a green card holder with immediate permissions to work and travel. Then from there, you get the actual physical green card in the mail from there. One thing to consider that I don't think that are on the slides per se, but is the difference between a 2-year green card, a 2-year conditional green card for those who get their green card is based off of marriage, versus the 10-year green card. So the 2-year green card are given to those, the conditional green card are given to those applicants or the beneficiaries who have not yet met their 2-year wedding anniversary. So those who are less than their 2-year wedding anniversary get a 2-year conditional green card. Once that 2 years is coming up, then the applicant spouse, the beneficiary spouse, again, has to prove to USCIS, this time to USCIS specifically, that they're still in a good faith relationship. Everything is fine and dandy. Here's additional information and documents to prove to you that we're still in a good faith relationship. Cori, can somebody who divorced prior to their 2-year wedding anniversary, or before the expiration of their green card, rather, the conditional green card, can they still get the conditions of their green card removed?
Yes, if you're not with the spouse that you were with when you obtained your green card, there still is an opportunity to remove the conditions on your green card and get a 10-year green card, as long as the marriage ended in good faith and you can show that. And there are a few other humanitarian exceptions as well for that.
Right. So with that, what the government is focusing on is when you first got married, did you marry for love or did you marry for a green card? If you married for love, prove it to us. Show us that you tried to make it work, that you're in a good faith, you were in a good faith relationship and it just didn't work out. And that's okay. And they will still be able to approve that. And like Cori said, there are some additional humanitarian reasons that USCIS will grant it as well. The January Visa Bulletin. So what the Visa Bulletin is that it dictates how many people from each country can enter the United States under each visa category. So here you'll see there's a handful of family-sponsored preferences, immediate relative, or like the spouse of a US citizen or the parent of a US citizen, for example, the child of a US citizen under a certain age. They don't fall under the family preference category because they're immediate relatives, and they don't have to wait for their turn in line, essentially, or what Cori likes to tell people, they don't have to wait for their golden ticket. So what the Visa Bulletin is a quota system where USCIS will, the Department of State dictates, again, how many people from each country can enter the United States on any given year. And then it's updated on a monthly basis. So tell us, Cori, a little bit about specifically, I guess, the F2A category here.
So
What's so
this,
special about this category?
yes, the F2A category is specifically for spouses and children of permanent residents. And as you can see on the screen, it's showing a C, which means that this category is, or preference category is currently current, which means that a green card holder who is filing for a spouse or a child can also concurrently file for the green card, because there are visas available right now in this specific category. They don't have to wait necessarily for their turn. There's not a wait time there.
Awesome. And historically, has it always been current? Why are they even on this visa bulletin if it's current right now?
Historically, it's always been about a 2-year wait, but right now it is current. It's been current for about a year and a half. But generally, in the past, it's always been about 2 years.
Okay, got it. And then so there's table A, and then on this next slide you'll see there's table B. This was it's not even new anymore, actually. It's been this way for many years now, but this confuses so many people, immigration attorneys included. Table B means that individuals whose priority date comes up on this, and what I guess that's what we should explain. What is a priority date? A priority date is when you file that initial foundational I-130 petition. So when did you file that I-130 petition? That's your priority date. Once your priority date matches or precedes what is listed on these tables, then table A and B mean two different things. Table B means either you can file the subsequent application with USCIS, for example. If the individual is in the US on valid status of their own, you can file that I-485 application and USCIS will accept it. Or if you are filing through consular processing and it's current on this page, on this table B, the National Visa Center will reach out to you to obtain additional information and essentially move on with the case. Table A, going back to the previous slide, table A means these people, it's their turn. It's their time to get their green cards. And there's no more, obviously you have to wait for your visa interview and everything, but assuming you go to your interview and your priority date is current on this table, they can issue you your green card. One more thing to mention as well is USCIS has a different, they look at either table A or table B, and the Department of State, so the consular processing cases, will either look at table A or table B. So the consular processing cases always will look at table B first, where the National Visa Center will reach out to you. And then table A is when your case can be scheduled for interview, and then they can put that final stamp in your passport. USCIS, more often than not, will actually move forward with table A. Why they do that, I don't know. I don't question it because it works in everybody's best interest. So just, again, another immigration complexity that is not necessarily easy to follow. Walk us through the changes that have already started to happen with Biden, and ones that will happen as well. Actually, let me start. So Biden has a 6-pillared immigration plan, and this is what are the 6 pillars of immigration that he is going to be focusing on. I'll walk you through them. So unraveling Trump's damage. But depending on the person that you talk to, some will say there's more, some will say there's less. Modernizing the immigration system. Immigration law, we say it all of the time, is pretty archaic, like the quota systems, and the fact that some countries have quotas while others don't, is archaic, and it needs some freshening up. Welcoming immigrants, this is a huge thing, and we've already seen it with actions that President Biden has already taken. But the last 4 years have been incredibly anti-immigrant, and so we're so grateful to have an administration in place that is welcoming immigrants. an administration that is going to be supporting asylum seekers and refugees, tackling the root causes of irregular migration, and then just implementing an effective border screening. So the 6 pillars of what Biden says that he will be doing. So Cori, what has he done thus far?
Yeah, so President Biden has stayed busy, definitely with immigration the first week. So there's a bunch of things that he's already done. We've listed a few of them here. He has issued a proclamation to end the Muslim ban. He has issued an executive order revising immigration enforcement policies to shield undocumented immigrants from deportation, another executive order incorporating undocumented immigrants into the census. He's also pulled funds from the border wall, so that's no longer moving forward. And he has issued a memorandum strengthening DACA, and he has suspended new enrollments in the Migrant Protection Protocols program. So this is a program that started during the Trump administration, and it would allow border officials to essentially send non-Mexicans back to Mexico while they awaited their court hearing dates in the US. So that is now being suspended at this time.
Awesome. And then moving on, keep going, Cori.
Yes. And then in addition to that, Biden has also sent an immigration bill to Congress as part of his commitment to modernizing the immigration system. This bill had many provisions, but just to highlight a few of those provisions, and probably one of the biggest ones there is that this bill, if passed, would provide a pathway to ultimately citizenship for dreamers, TPS holders, immigrant farm workers, and even undocumented individuals, so individuals who don't hold any status at this time. It would require that any applicant be physically present in the US on January 1st of 2021. But this is something that is exciting, that if it were to get passed and move forward, it would be great. We don't know what the ins and outs are going to be of it at this time, but it is something that is now in the hands of Congress. As far as the other provisions go, just to give a bit of a highlight on some of those, it also included increasing the cap for diversity visas, getting rid of 3 and 10-year bans. So these are bars that were created back in the 90s that often prevent people from getting legal status in the United States or really obtaining a green card because of their illegal entries into the US. The other provisions were included eliminating lengthy wait times, recapturing unused visas. But essentially the goal for this whole bill is to keep families together, embrace diversity, and it has a lot of exciting changes. So hopefully it does move through Congress. In addition to this bill and the proclamations and memorandums and executive orders that have already been issued, President Biden also has other things in his he has set forth plans to make other changes in U.S. immigration law. One of the biggest ones, I think Anita will agree, is for us personally that we've dealt with on a regular basis is reversing the public charge rule. So we would love for this to not be a thing anymore. But basically the public charge rule that was created under the Trump administration seeks to determine if immigrants are going to use public services, so food stamps, federally funded health insurance. So it puts a higher scrutiny on people who actually need these resources. It's actually a negative for them. So it's something that we would love to see actually go away. And then other things that are part of Biden's plan are streamlining the naturalization process, providing support to those holding TPS, restoring the discretion of immigration officials, giving opportunity and flexibility, and simplifying the green card process, increasing access to language instruction for new immigrants, providing help for undocumented individuals who have served in the US military, as well as placing more humanitarian resources near the border to support refugees and migrants, ending prolonged detention. So right now, people are held in detention for a very long time. So he wants to create some, especially for children, he did mention creating a case management system that would allow children to be connected with relatives in the US at a much quicker pace, ending that prolonged deportation, and then investing in resources to make the deportation system more efficient, effective, and fair. In addition to all those things stated above, he does have a big focus on the negative asylum policies that have been put in place since the Trump administration. One of them was starting with suspending that migrant protection protocol program that I discussed earlier, but in addition, restoring some of the asylum eligibility possibilities. So before the Trump administration, domestic violence survivors were able to gain asylum status by showing that they were victims of abuse and their home country wasn't going to be able to protect them. But during the Trump administration, we saw that eligibility possibility kind of eliminate and go away as those cases were being denied. So he has talked about bringing that opportunity back to those people who really need it. So these are just some of the things.
So Cori, how come you can only kind of speed through all of those changes? I'll answer that silly question for you. We don't really know exactly what is going to happen. Obviously, the first slide or actions and things that we see that the Biden administration has already began working on, but everything else is kind of just I don't want to say campaign promises, because we obviously have high hopes that Biden is going to really be focusing on immigration during his time as president. But we don't necessarily know everything just yet. We aim to obviously educate ourselves and be able to educate all of our clients and just people in our network as well to help guide them of what is forthcoming and what the changes actually are. But stay tuned with us. We truly and genuinely look forward to the next 4 years. We hope that there truly will be that positive change that all of our clients, all immigrants in this country can benefit from. We started off as a country of immigrants, so we look forward to being that place where people do want to continue to realize their American dream. I think over the course of the past 4 years, people lost sight of that. They're like, what American dream? And we hope that we can go back to that, where America is this immigrant friendly place and country where people want to come, people want to invest their time, resources, and their lives here. So thank you so much. That's all we have necessarily scheduled to talk to you guys about, but let's go ahead. Right, so we have a question. What is the likelihood of administrative closure being reinstated under the current administration? So administrative closures are definitely a thing of the past. I don't think that we've necessarily heard any rumblings or rumors thus far that it is going to be reinstated under the new administration. Cori?
Yeah, as far as the most recent information that we received from some of the local offices is that they do plan to keep all of the U.S. immigration offices open, even with rising COVID cases. They do have plans to stay open and continue to process cases and get through their backlog. And we, like Anita said, I haven't heard anything about possible closures again.
What is someone is not on legal status, but say a student on OPT H-1B visa and gets pregnant in the US for the birth? What is the process for them to stay back in the US, or do they have to go back? So if you're, I believe this question is, if you're in the United States and you're on the verge of having a baby, there's options for you. Maybe it's changing your status. If you do have legal status, changing your status to that of a tourist, assuming that you do have health insurance that you can get in the United States. But if this is a specific question that is true to you, reach out to us. Let's consult with you so that you have some guidance or some clearance on what you can do moving forward for you. What kind of documents do I need for a marriage green card? Cori, can you give us some document suggestions? First of all, let me say, if you are considering a marriage-based green card, reach out to us. Let's see if we can help you. If we can help you, once we do get started with the case, we will send you a thorough checklist of documents that will help kind of pick your brain to see what you do have to put together a strong case, and what other options there are for you in terms of documents. But Cori, can you give us some ideas of like some marriage-based marriage bona fide documents that clients can give us?
Yeah, so first, I mean, there's a variety of documents that you can provide, but some of the best ones are proof of sharing a residential lease together, a joint bank account, joint credit cards. Obviously, if you have children together, that's always a good marriage document as well. And any kind of shared insurance policy, things of that sort. So all of those documents that would have both spouses' names on are going to be great to prove bona fide marriage.
And then what about other documents that we need from the applicant, like vital documents? What do we need?
Yeah, so other documents that you would need are going to be identity documents like birth certificate, any documents related to prior immigration history, proof of your spouse's either citizenship or green card holder status, so things like that.
And then let's talk kind of financial dependency for one quick second. So as a petitioner, as a US citizen or a green card holder petitioning for a spouse or any relative, actually, you have to also financially sponsor the individuals that you hope to be bringing to the United States. So with that, you need to be making above the poverty guideline and prove to the government that you make above the poverty guideline, and you yourself can financially support this individual in order to enter the United States or remain in the United States as a green card holder. So what the poverty guideline looks like, let's say I'm petitioning for my spouse and I have no other dependents on my taxes that I claim, for example, or I just don't have any dependents. Minimally on an annual basis, I need to make above, like, it's realistically like $25,000 annually. If I don't make that, then I can at that point in time ask for somebody else to be a joint sponsor on my case as well. So somebody who's over the age of 18 is a green card holder or a citizen who makes above that poverty guideline can then support my application by being a joint sponsor. And documents that you need to prove either as the petitioner or as the joint sponsor in these applications is you have to prove that you do make above the poverty guidelines. So you have to prove that by providing an employment verification letter to say, this is Anita, this is where she works, this is how much she earns annually or hourly or whatever it may be. And then you also have to support with at least three of your most recent pay stubs and then your taxes as well. Some people don't have this. Maybe I own my own business. There's ways around it. So those are additional documents that you would need as well. Next question. Should I sponsor for my fiance who lives in another country, or should I wait until we are married? That is a good question. And that is a question that comes up a lot in my consultations, where somebody will reach out to me and will say, or both of them are on the Zoom call, and they'll say, we want to be together. We're not yet married. Tell us what we can do. And I'll walk through both pathways with them, the K-1 fiancé visa pathway or the I-130 consular processing spousal green card pathway. And ultimately and realistically, what it comes down to is, what is that individual couple's, what are their primary goals? Is their goal to be together ASAP? And by ASAP, as soon as possible in immigration standards. It's not very fast, but we can hope. So it's either coming together sooner than the marriage-based pathway. But when you enter the United States on a K-1, you don't have immediate permission to work in the United States and travel internationally. You're you enter the United States and you have to wait several months before you have that work authorization. Or if somebody tells me not working is not an option, Anita, I have to be able to work, I have to be able to contribute, then I'll say, okay, then forget the K-1 visa. You are going to have to remain separated for a little while longer. However, once you do, ultimately, you guys will have to get married, and then you go down the marriage-based pathway. Once you're married, then you can enter the United States as a green card, go through the green card process, enter the United States as a green card holder with that immediate permission to work and travel internationally. One question that clients often ask me as well in relation to this of picking the difference between marriage marriage or fiance. With either option, if the person has if they have a visitor's visa, whether it's a B1, B2 tourist visa, or their country is an ESTA country, you can still enter the United States as a tourist while the case is ongoing. So that won't necessarily preclude you from visiting still, but it's still a pathway. Next question. I just received my US citizenship, and I want to bring my mom and her husband, not my biological father, that live in Latin America. Can I get them green cards? Your mom, yes, 100%. You can petition for your mom to enter the United States. Your stepfather, so it's not your biological father, but your mom's husband, you may be able to petition for a step parent. And in order for you to be able to petition for a step parent, that step parent relationship must have started. So your parents had to have gotten married before your 18th birthday. If they did not get married before your 18th birthday, then unfortunately you directly cannot petition for your stepfather. However, there's still options for you. So it would take a longer while for your stepfather to enter the United States. But once your mom is in the United States as a green card holder, then your mom can petition for your dad for him to enter the United States, or your stepdad for him to enter the United States under the F2A category. And based off of what everything Cori said earlier, hopefully the F2A category will continue to remain current, and there won't be too much of a delay of entry. So it is an option, and it is a pathway. The next question, give me one, sorry, technical difficulties. Okay, next question. For clients to have their interviews abroad, how have you seen some of these cases move during the pandemic? So some cases can move forward. Some of these cases can move forward despite the pandemic, despite the green card bans, for example, at the consulates, while others cannot. We've had a handful of spousal applications follow through interview and then ultimately enter the United States. So what this means is, again, with that green card ban, there are a handful of exceptions from the proclamation that says no more green cards to be issued at the consulates abroad. One of them being the spousal green card route. I'm sorry. So if you have petitioned for your spouse and your case is waiting to be scheduled for interview, reach out to us so that we can help you get in contact with the consulate or embassy to let them know, hey, this person is not subject to the visa bulletin or the green card, bans, and we can help them enter the United States. Sometimes even the cases that are still subject to the exemptions from the green card bans are still not being scheduled for interview just because of specific consulates, what their individual policies are. Some of them will say absolutely no interviews whatsoever unless somebody is dead or dying. It's unfortunate, and kind of every consulate does what they want, and they'll interpret the various the various proclamations and all differently. So if you find yourself again in this situation, please do reach out to us. If I enter, yes.
I was just going to add to that there are some interviews being scheduled, but it is very, very slow moving. So I think you've already said that, but
we're seeing movement. Consulates are operating, consulates are operating under COVID guidelines. After they all closed at one point, they've all reopened, and they're moving through slowly. I think we have time for 1 or 2 more questions. Let's see what we can get through. So if I enter on a B2 visitor visa and marry a United States citizen and leave the USA, then my spouse applies for a green card for me, would I be able to re-enter the US on a B2, or does it get canceled and I only re-enter once I get my green card? So this is what I touched upon a little bit earlier. It all depends. You are able to enter the United States as a visitor, and you're allowed to get married so long as you leave the United States. Don't overstay your visa. Get married and then go back to your home country and start the consular processing route for you to move forward with getting your green card. Your B2 visa is not going to get canceled just by virtue of filing an I-130 petition. If you're going through the consular processing route, and I've had a ton of clients in a situation like this where the individuals filed and they entered the US, they got married, then the beneficiary spouse went back to their home country, and then still did come back and forth using their visitor's visa until ultimately the green card was issued at the consulate, and then they entered the United States. So it's feasible, it's an option, and definitely consult with an immigration attorney before you do any of this. I kind of will say that across the board. Before you do anything, consult with a professional just so that they can support you through the process. And things can be possible, but you just want to be aware of all of the risks that you would be exposing yourself to. That is all the time that we have today. If I did not get to your guys' questions, please feel free to reach out to us via email or just contacting our office. Thank you all so much.